John Hayes.
Mr Chair, I move that the question be now put.
I call Eugenie Sage.
The silence from the government benches has been quite astonishing, and I think it shows that there is nothing that they can do to defend this bill, and the very spurious reasons that they gave in the first reading for its introduction. And as the Christchurch Press in an editorial said, that the continued suspension of democracy at Environment Canterbury is, and I quote, the most radical denial of voting rights that this nation has experienced in recent times, and it's something that besmirches the government and denies Cantabrians a fundamental right. And Mr Chair, I think it's consistent with what this government is doing in local government. The Honourable David Parker talked about the way in which the bill overrides or denies the right to appeal to the Environment Court. And are we going to see that same denial of rights to the Environment Court in the local government reforms that the government introduces later this year? Are we going to see a continuation of the centralisation of power in Wellington and local government regarded as an agent of central government rather than having a mandate in its own right because its councillors are elected and they get that mandate from that election? Because what we've seen in Environment Canterbury and in this bill, Mr Chair, with the denial of appeal rights to the Environment Court, the appointment of commissioners, the changes to water conservation orders, is a fundamental denial of democracy in Canterbury, and we think it is symptomatic of the other changes that this government is putting on local councils and local government. And it is rich, Mr Chair, because this government derides the term nanny state, and yet it is taking an awful amount of power to the state, to central government, and cutting right across the ability of local government to represent the people that elect them. And we've seen that, Mr Chair, with the changes in the RMA Reform Bill, which deny the Auckland Council the right to appoint the hearing commissioners to hear submissions on the Auckland Unitary Plan. Here in the ECAN Bill, we've had councillors denied the opportunity as elected representatives to make the policies for the region through regional plans. That's been supplanted with appointed commissioners. Are we going to see the same in changes to local government where we have councils around the country denied their right to make decisions on their plans through increased intervention powers for the Minister in the Chair? We've seen that in the Local Government Act changes last year, with the Minister much more easily able to intervene, and yet this bill that we have now could have implemented the advice of the Minister's own commissioners at ECAN. It could have moved to a transitional model. It could have implemented the advice of officials to restore the water conservation order provisions of the RMA fully in Canterbury, and that's why, Mr Chair, there is a supplementary order paper 176, I think, in my name, which actually makes changes and inserts a new clause 10 after clause 9, which would restore the law elsewhere in New Zealand to Canterbury in regard to water conservation orders. Because, as David Parker noted, there are several water conservation orders in Canterbury. He missed Te Waihora Lake Ellesmere. There are other rivers which deserve that status. Mr Chair, water conservation orders are the mechanism to recognise that rivers have outstanding values which deserve protection. And both the Parliamentary Commissioner and the New Zealand Conservation Authority recognise their value and the need for a representative range of rivers throughout New Zealand to be protected through water conservation orders. What would the government lose except to admit that it only cares about rivers for irrigation? If it agreed to this supplementary order paper, it would be restoring some measure of good faith to water management in Canterbury by making sure that we have the same law across all of New Zealand. The Minister hasn't taken a call recently. Would encourage him to take a call to say why we can't have the same law in Canterbury in relation to water conservation orders as applies everywhere else. And it would be too big an ask of this government to restore democracy, But given the radical denial of our voting rights, again without any substantive reasons from the government, would be interested in the Minister's comments as to why we cannot have democracy back in Canterbury.
Call Andrew Williams.
Thank you, Mr Chair. Take a call on behalf of New Zealand First on this very important bill.